Good morning, everyone. I'd like to call to order the Judiciary Committee meeting for April 12, 2024. The committee is going to stand in recess. All right. Good morning, everyone. Like to reconvene the Judiciary Committee meeting for April 12th, Friday. Happy Friday. All right. Let's start with number 2 on our agenda, which is substitute for House Bill number 5168. An act concerning solar installations in condominiums and cooperatives. The motion is a JF. Motion from Senator Kissel, second from Representative Fishbein. This is a bill that comes to us from the Planning and Development Committee involving condominiums and particularly solar installations on individual units within a common interest community. I believe the reason it is before us is because, at least traditionally, Common Interest Ownership Act bills have originated in this committee, although this one seems to have originated in the Planning and Development Committee. But be that as it may, seems to be good policy. Questions or comments from the committee? Questions or comments? If not, Representative Fishbein for a motion, please.
Mr. Chairman, I make a motion that we create a consent calendar and then we move HB 5168, an act concerning solar installations in condominiums and cooperatives to that consent calendar.
Is there objection to placing the item on consent? Is there objection to placing the item on consent? If not, that'll be so ordered. Next, substitute for House Bill number 5226. It's number 3 on our agenda, 5226. An act establishing an extended producer responsibility program for consumer batteries. The motion is a JF.
Second.
Motion from Senator Kissel, second from Representative Quinn. This is a bill that comes to us from the Environment Committee. It seeks to establish a program for consumer battery recycling. I believe the reason it is before us is the civil enforcement and criminal penalty provisions that are towards the tail end of the bill. I'll note that there is a $7,000 fine that is prescribed for certain violations. There also is a Class A misdemeanor incorporated in the bill for falsification or making a fraudulent written material misstatement, among some other provisions. And with that intro, I will actually turn to Representative Fishbein to discuss this a little further. Representative Fishbein.
Thank you, Mr. Chairman. There's certain aspects of this bill that do fall within our cognizance, yet are a bit murky and unclear, and perhaps violative of prior public policy. And with that, Mr. Chairman, I make a motion that we strike from lines 641 through 642 the clause "or pursuant to a form bearing notice to the commissioner," and that we strike lines 671 through 675 because by concept, we do not subpoena parties to make them parties to actions of cases. So that's not in line with our current law. And to strike lines 683 through 687, which created an immunity. However, the immunity is perhaps improper. So moved.
Second.
So there's a motion from Representative Fishbein, a second from Senator Kissel. I do believe this amendment is, I do believe amending this bill is proper, and I support the amendment. I think it's necessary cleanup to the civil provisions of this bill, as was noted. The language in lines 641 to 642 are confusing at best. 671 to 675 are not, either somebody's a party to a litigation or they're not a party to litigation. I don't know why we would prescribe this, and that the language in here makes no sense. And I think the immunity provision goes too far and would essentially exempt anyone from a CUTPA violation, which just goes beyond I think what we as a committee generally look at as favorable policy. So with that, I support the amendment. Is there further discussion on the amendment? If not, I will just double check with LCO. LCO, are you clear on the amendment?
Mr. Chairperson, with regard to the changes on lines 640 to 644, am I to understand that we would insert a bracket before the word or in line 641 and then insert a closing bracket in line 643 after section?
I believe the closing bracket would actually go after the word commissioner.
Correct.
Thank you.
All right, so I believe we're clear on what the motion is. I believe there's no further discussion. Let me try your minds. Oh, Senator Flexer on the amendment.
Thank you, Mr. Chair. Mr. Chair, could I just for clarity, could the amendment be explained one more time?
Absolutely. So the amendment on the floor is to strike from lines 641 through 642 the words "or pursuant to a form bearing notice to the commissioner." And then to strike lines 671 through 675. And to strike lines 683 through 687.
And what's the purpose of that, I guess, is what I'm just trying to discern.
The purpose to this, as we just said, is to put this more in line with existing court process and procedure. Certainly with respect to the change to line 641 to 642, if someone makes a false statement under oath, then yes, that is an A misdemeanor. That's existing law. I'm not sure what the words or pursuant to a form bearing notice to the commissioner means or why that would need to be inserted. The change to lines 671 through 675 seems to imply that someone could be made a party to a litigation simply by subpoenaing them. That's not the case. You are impled into a litigation or named at the outset. And so that clause creates, I believe, confusion in our court process. And lines 683 to 687 seem to provide immunity from certain action to certain organizations with respect to CUTPA violations, which I think is too broad and not in line with the policy that is generally adopted by this committee. Further questions?
Thank you. I appreciate that. Have these changes been discussed with the chairs of the committee of cognizance that sent the bill to us?
In fact, I did discuss this with the House Chair of the committee. But these are clearly changes that are within the cognizance of this committee. And frankly, the reason the bill is here is for us to make sure that a bill like this that creates a new fine and a new criminal penalty and new court procedures match up with our expectations. So yes.
Thank you.
Further on the amendment? If not, I'll try your minds. All those in favor, please signify by saying aye.
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 Opposed, nay. The ayes have it. The amendment is adopted. Further on the bill as amended. Further on the bill as amended. If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5226 to JFS it with the floor with Amendment A. Winfield,
Winfield in the affirmative.
Staffstrom,
Yes.
Flexer,
Yes.
Quinn,
Yes.
Kissel,
Yeah.
Fishbein,
Yeah.
Blumenthal, Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney in the affirmative.
Dillon, Doucette,
Doucette, yes.
Stubitsky,
Yes.
Elliott, Gaston, Gilchrist, Godfrey,
Godfrey votes yes. Godfrey votes yes.
Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Johnson votes yes.
Khan, Labriola, Lesser,
Lesser, yes.
Mar,
Mar, yes.
Miller, O'Day.
Miller, yes.
Thank you. O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato, Porter,
Porter votes in the affirmative.
Sampson, Sims,
Sims in the affirmative.
Veach,
Yes.
Walker, Wilson,
Thank you, Madam Administrator. Madam Administrator, we are going to hold the votes until 2 o'clock today for members. All right. Next, we're going to go to item number 4 on our agenda, substitute for House Bill number 5288, an act aligning state law with federal law concerning service animals. The motion is a JF. Motion from Senator Kissel, second from Representative Fishbein. This is a bill that comes to us from the Veterans Committee, which I think seeks to redefine the definition of a service animal in our state statute to meet up with federal law. I will note that the new definition appears to be somewhat more expansive than our current definition in some respects. The places where this committee, I think, has primary interest or cognizance is with respect to sections 13 of the bill, which I believe addresses negligence actions, and also with section 14 of the bill, which deals with victim impact. Discussion on the bill. Discussion on the bill. If not, Representative Fishbein for a motion, please.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move HB 5288, an act aligning state law with federal law concerning service animals, to the consent calendar.
Is there objection to placing the item of consent? Is there objection? Seeing none, so ordered. Number 5, substitute for House Bill number 5331, an act concerning the suspension of motor vehicle operators' licenses for failure to pay fines or fees or failure to appear for a scheduled court appearance. The motion is a JF.
Second.
Motion from Representative Porter, second from Representative Quinn. This is a bill that comes to us from the Transportation Committee. My understanding from discussing this bill with the Transportation Chair is that there was testimony that we are one of the few states that actually suspends someone's driver's license for not showing up at a court appearance or for failing to pay a court-imposed fine. Of course, under our existing law, if someone fails to show up for a court appearance, they can be and in fact are charged with failing to show up at a court appearance. That is a judicial proceeding. It's a judicial procedure, and they can be charged accordingly. To add on to that, suspending someone's driver's license, which is extrajudicial, seems out of line with what we do in the context of not showing up for other court appearances. Similarly, under this bill, if someone is, or under existing law, if someone is gets a speeding ticket out of the state of Connecticut, their driver's license can be suspended in Connecticut for not paying that fine. I don't believe, my understanding, like I said, from the Transportation Committee, is most other states do not do that. And this bill would prevent that from happening. Discussion on the bill. Senator Kissel.
Thank you very much, Chairman Staffstrom. I'm going to oppose this. I don't see why we should be taking a step, as I would characterize it, backwards. There's been lots and lots of news reports and data that we seem to have had an increase in traffic violations. And unfortunately, in some areas of of our laws. There seems to be disrespect for the rule of law. And it doesn't seem to be moving necessarily in a positive direction, especially regarding things such as inappropriate driving patterns, stealing cars and the like. I understand the desire to try to bring this into comportment with other states. But at this point in time, given my constituents' concerns and my observations of the direction our state is going, I don't think that this would be a priority up in my neck of the woods, and therefore I'll be opposing it and voting no. Thank you, Mr. Chair.
Further on the bill, Representative Fishman.
We thank you, Mr. Chairman. I'd like to align myself with the remarks of the good senator. You know, we do have a problem in this state that I run into from time to time with people not appearing for court. And we don't have people out there, you know, searching for these individuals, you know, charged with, okay, this person didn't appear for court, go find them. The only way that they're actually brought in is if they somehow come into line with the system. They get pulled over for something. There's perhaps a warrant, which to my knowledge, there aren't warrants automatically issued. And to say that, you know, we already have a problem over the last 2 years with increased motor vehicle death on our highways. These are motor vehicle violations. So, you know, I concur that rolling things back and taking away penalties for individuals that don't appear for court, that's important. They've already, something's going on with the legal process. They've been given a promise to appear, but they break the promise. I don't think this is the right way to go. So thank you, Mr. Chairman.
Further questions or comments? Representative Howard online.
Thank you, Mr. Chairman. My apologies for not being there. I'm still battling this cough on the rainy day. I stand in opposition to this bill, and I want to clarify a few things. Currently in the state of Connecticut, if you get an infraction for a criminal offense, for example, creating public disturbance is an infraction. Simple trespass is an infraction. And you fail to answer that, generally a failure to respond warrant is issued for your arrest. When you come in contact with a police officer, taken into custody, and you answer that failure to respond charge. When you get an infraction, say speeding or motor vehicle related offenses, there is no warrant that gets issued for you when you fail to send that in. So if I get a speeding ticket today and crumble it up and throw in the garbage and do nothing, there's no warrant for my arrest. I simply get my driver's license suspended, and that's it. The representation that both things are happening is just not accurate. When we talk about motor vehicle infractions, that's not what's happening. You get your license suspended. If you get subsequently stopped, then you would be charged with, you know, operating under suspension. You would get a court date at that point. Certainly, if you fail to appear to that court date, then there'll be a failure to appear warrant issued for your arrest. As the Chief State's Attorney noted in the bottom of his testimony, if this bill were to pass, somebody who gets an infraction simply for speeding and throws it in the garbage, we essentially have no recourse to force them to pay that fine or stop speeding. I should note for members of this committee that as of a couple of days ago, in 2024, we have experienced 87 fatalities on our highway. We are on our highways in this state. We are at this moment on track to surpass 2022 and have the highest rate of fatalities in Connecticut in over 40 years. That is a serious, serious concern. When I testified in transportation earlier this year on a different bill, unrelated here, I made the point, distracted driving causes accidents. Intoxicated driving causes accidents, no doubt. But the leading cause of fatality as a result of an accident is speed because of physics. Certainly if I'm texting and driving at 25 and hit a tree, or I'm texting and driving at 100 miles an hour and hit a tree, we're talking about significantly different outcomes. The speed on our highways is the contributing factor to this high rate of fatalities beyond anything else. Any one of us who drives to Hartford on the daily knows right well that the average speed on our highways is excessive. Okay. And now we're going to tell the people of the state of Connecticut, if you happen to get a speeding ticket, which is not even likely right now because of the state of law enforcement in the state anyway, if you happen to get a speeding ticket, throw it in the garbage. Nothing's going to happen to you. That is totally backwards to what we should be doing in this state. Now, I understand that we have an infraction schedule that is the same for everybody. And I can appreciate individuals with higher incomes can get a speeding ticket and pay it, no big deal. Individuals with lower incomes, it has a much more far-reaching effect on them because it's much more difficult to pay. And I'm willing to sit at a table and have a conversation about ways that we can overcome that, but never to the extent that we are going to enable speeding on our highways in this state and continue to lose lives unnecessarily. Frankly, Mr. Speaker, I want to give a great compliment to Commissioner Euclid, who submitted testimony in this bill that I read, and he had the courage and the integrity to stand up and say, hey, this is a major problem. That gentleman has taken seriously his role as Commissioner of Transportation to get safety back on our highways for those who commute through our state on the regular as residents or those who visit us. He has taken it seriously. I'm a little disappointed that Judicial and the Chief State's Attorney's Office submitted testimony taking no position, though they did recognize and point out the problems with it. And I'm more disappointed that the Commissioner of Public Safety has not submitted any testimony in opposition to this. This is a major, major, major issue in the state of Connecticut, this speeding and these fatalities on our highways. And voting yes on this today, not only does nothing to affect that and make it better and make it safer, but in fact, Mr. Chairman, it does the exact opposite. We are going to tell people in the state of Connecticut, if we pass this bill, hey, go ahead and speed. You get a speeding ticket, throw in garbage, do whatever you want, and we'll just have massive fatalities. That is horrific public policy, and I assure you, I will not be a part of it. And I encourage all of my colleagues today to vote no on this. Thank you, Mr. Chairman.
Representative O'Day.
Thank you very much, Mr. Chairman. I want to echo the comments of my ranking members and Representative Howard. This is horrible policy. This will, I guarantee you, make our roads less safe. It will increase speeding. I sat on transportation and not a single one of my colleagues on this side of the aisle voted for this legislation. This is horrible policy, horrible legislation, which will absolutely result in more deaths on our highways. I guarantee it. And so I am vehemently, adamantly opposed to this legislation. And I beg my colleagues, if you have to vote against this legislation. It's just horrible policy, in my humble opinion. And thank you, Mr. Chairman. I appreciate the time.
Further questions or comments on the bill? Representative Porter.
Thank you, Mr. Chair. I just want to ask a question. It is my understanding, this is for clarification, that we are indeed have checks and balances in this bill where if a person is guilty and they haven't showed up for court, when they go to renew their license, that is when they will be subjected to suspension or, okay, if you could just elaborate on that, because what's being said is quite disturbing to me, because I do plan to support this. And I also want to say that there are several reasons why people don't show up to court, but there are also people that show up to court and get a continuance over and over. And we're not taking into consideration their work schedules, their personal life schedules, and what they have going on and why they may be missing court. I don't think that it's always because somebody's throwing a ticket in the trash. So I just want to put that on the record as well, from conversations that I've had with people that have been impacted and had their license unknowingly suspended through. Thank you, Mr. Chair.
Thank you, Representative Porter. And yes, I was just going to mention that, and I appreciate the prompting. So no one, I certainly don't believe the proponents of this bill who, and I do recognize the Transportation Committee has worked hard to try to increase traffic safety on our roads. In the last few years, we've had bills come to us from the Transportation Committee to institute red light cameras or to provide automatic enforcement on our highways with respect to work safety zones. And in each of those bills, there were provisions that specifically said failure to pay the fine that was mailed to someone would not be grounds to suspend someone's license. We have gone down that road with respect to automatic enforcement. And the reason for that is certainly I know in my community, and I know in your community as well, Representative Porter, folks move around. So if something is sent to them in the mail, they get notice, they might not necessarily get it. and we don't serve things by marshals or registered agents, and the like. So what we have is a process whereby if someone doesn't show up at court, a failure to appear can be instituted for them for not showing up in court. We also have a process whereby if someone goes to renew their driver's license and they have outstanding fines, they can be forced to pay those fines before they're allowed to renew their driver's license. That is the proper enforcement mechanism. And I don't think anybody is saying someone should be able to tear up a ticket and throw it in the garbage. Let's not inflame this. Let's look at the policy. The policy is if you get a ticket and you don't pay it, you should pay the ticket, maybe even with interest when you go to renew your license. But what should not happen to you is you should not have a ticket, maybe from outside the state of Connecticut, that is not paid. You're driving around on a state road with a license that you don't know is suspended because it's been administratively suspended by the commissioner without any notice, without you receiving any notice. And as Representative Howard just alluded to, what then ends up happening is you get pulled over for an unrelated violation. Maybe for having window tint that's too dark, or maybe for having one tail light that is out, and you get pulled over for an unrelated violation, and it's then determined you have a suspended driver's license that you didn't know was suspended because you got a traffic ticket in some other state. Maybe it was an automated traffic ticket in another state that you didn't know about and you didn't pay. And now all of a sudden you're being hauled into court for driving on a suspended license. You didn't intend to be driving around Connecticut on a suspended license, but that's what happened because our laws allow for suspension of driver's license even in those types of situations. That's what this bill attempts to address. Further questions, Representative Porter? Thank you, ma'am. Further questions or comments on the bill? Representative Fishbein for a second time.
Thank you, Mr. Chairman. Mr. Chairman, I'm looking at the actual language that we're voting on here today. And it says that it's prohibiting the commissioner from suspending a driver's license if the person failed to pay any fine, fee, or other charge associated with an infraction. So I'm just trying to bring it back to what Representative Howard was talking about. When somebody gets a ticket for an infraction and they tear it up and they don't pay that infraction, which was his scenario, I think that's right in line with what we are barring. The person is not paying their fine or fee related to that infraction. So I'm trying to put together what appears to be a disconnect here. And I'll tell you that procedurally, prosecutors are usually very accommodating of getting people through this process. You know, many times meeting with the accused at motor vehicle docket the first time and saying, you know, trying to work out a deal, maybe a charitable contribution or something, or, you know, maybe saying to them, well, you know, okay, you would like to speak with counsel. I'm going to give you a new date. You know, those kinds of things do happen. But what this deals with is where, you know, the prosecutor perhaps is being so accommodating, is giving the individual their new court date and they just don't come. What do we do? And it comes back to where I started with this. So I do align myself with the comments of Representative Howard, and I do intend to continue to oppose. So thank you, Mr. Chair.
Further on the bill? Representative
Mr.
Howard,
Chair,
second time, Representative Howard.
Thank you, Mr. Chairman. I just want to clarify the bill before us in section 3 actually specifies that the commissioner shall, as I read it, and it lost me for a second here, but the commissioner shall not later than January 1st, 2025, reinstate motor vehicle operator's license for any person whose license was suspended solely for one of the both of the following reasons: that they failed to pay any fine or fee. The reason currently, when you go to renew your license, which by the way, you generally get your license for, I think, 7 or 8 years. I think it's 8 years now. So when you go to renew your license, why they won't renew it if you have outstanding fines is because your license is probably suspended. They're not going to renew your license if it's suspended. So I think the representation that if I got my new driver's license today and next year got a speeding ticket and threw it in the garbage and did nothing with it, that nothing really would happen to me for 6 or 7 years until I go to renew, and then they wouldn't renew it. I'm not sure that's accurate because currently that doesn't happen because it's suspended. This would not only prohibit that suspension, but it directs by January 1st, 2025, the commissioner to reinstate that license. So I don't think I was being inflammatory at all, Mr. Chairman. And your point about the cameras, when we crafted that language, there's a defining difference. And we did it carefully because the camera can't necessarily see the driver. They're basing it on the prima facie evidence that the registered owner is the driver. In an infraction issued by a police officer on the side of the road, the operator has been positively identified by that officer, generally through their driver's license, right? So that's why we did that. And as far as out of state, if Connecticut wants to withdraw from the interstate compact, which generally is relevant to speeding as a misdemeanor. So if you're from, say, Oregon, I'm not sure they're a compact state, but if they were, and you're going, 80 on a back road, that would be a misdemeanor summons in this state for speeding. Rather than saying you have to come back, we've made agreements with other states that you can pay the fine there and pay the fine instead. And if you don't, your state will suspend you. So there's recourse. That's so that we don't have people traveling across the state for a speeding misdemeanor. That's why we do these things. So if we're having a conversation again about Connecticut withdrawing from that because we find it unfair, again, I'm happy to have that conversation. But the fact is that as this legislation sits today, if it passes, the state and the chief state's attorney noted this in the bottom of his testimony, who do not pay a ticket, don't send it in at all. Certainly if they send it in and then they get a court date and miss the court date, a little bit different. Even though today that's only a suspension too. It's not an FTR for that, failure to respond or failure to appear. We don't treat it that way. But he notes in his testimony, if the person does nothing with that ticket, does not send it in, not guilty, doesn't send it in by paying it, but simply throws it in the garbage, there is no recourse. We have basically taken the enforcement of speed in this state and done away with it. That is a real concern. And I really think that we should be very cautious about this. And I think folks don't have to take my word for it. I'm happy to talk to people offline. We could talk to the Chief State's Attorney's Office. We can talk to Centralized Infractions Bureau. We could talk to the Commissioner of Motor Vehicles and get this understood correctly. But I have serious concerns that we pass this legislation. Thank you, Mr. Chair.
Representative O'Day.
Thank you, Mr. Chair, for the second time. And I'll just be brief because Representative Howard just said what I was going to say. Look, if we want to allow somebody who's driving 120 miles an hour in New Jersey and gets a ticket to not have their license suspended in Connecticut, we can carve that out, an out-of-state ticket. I think it's bad policy. It's the wrong thing to do. But our streets will be less safe if we pass this legislation. I guarantee it. And so I urge my colleagues to vote against this, what I believe to be horrible, horrible legislation. Thank you very much, Mr. Chair.
Further on the bill, if not, Madam Administrator, call the roll.
Roll call vote on House Bill 5331. Jay, put to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Plexer, Quinn,
Yes.
Kissel, Fishbein,
The block grant, but the
Blumenthal?
amount,
Blumenthal votes yes.
Callahan,
Representative Callahan votes no.
Conley, Curry, Delaney,
Delaney votes yes.
Dillon, Doucette,
Doucette, yes.
Dillon.
Dillon votes yes.
Thank you. Dubitsky,
No.
Elliott, Gaston, Gilchrist, Godfrey,
Godfrey votes yes.
Paul,
Paul votes no.
Harding, Hayes,
Hayes votes no.
Howard,
No.
Johnson,
Johnson votes yes.
Khan, Labriola, Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes no.
Osborne, Pavlock Tomato, Porter,
Porter votes in the affirmative.
Sampson, Sims,
Sims in the affirmative.
Beach votes no. Walker, Wilson,
Wilson votes yes.
Thank you. Next, we will move on to, back to number one, substitute for Senate Bill number 123, an act concerning course debt. The motion is a JF as amended by Senate Amendment A, which is LCO 3753. Motion from Senator Kissel, second from Representative Quinn. Is there discussion on this bill? Representative Doucette? Or actually Senator Miller or Representative Doucette? I think defer to you two if you'd like to go first.
I'll go first, Rep. Doucette. So this bill was a strike all amendment of the original bill, and it addresses the problem of coerced debt, which is a type of economic abuse that domestic abusers inflict on their victims. It came before us last year, and there's been quite a bit of work done on this bill. The advocates, CCAD, the Bankers Association, and the judicial branch all signed off on this. They had input and they signed off. We heard the concerns from last year's debate, and we addressed them in this bill. The bill also gives under the bill, a person who causes another person to incur coerced debt is liable, civilly liable, to the creditor for the debt and any attorney fees sustained by the creditor or debt in an action commenced under the bill. So, and it's also given the claimant a recourse as well if the coerced debt is established. So it's a far cry from what it was last year. It's a good bill, and I ask my colleagues to support it.
Thank you, Senator. Representative Doucette?
Thank you, Mr. Chair. And yes, I'll align myself with my good co-chair of the Banks Committee who summarized the bill. I'll only add, I think, that what this bill does is it creates sort of an extrajudicial process, first and foremost. And then if that is insufficient to resolve the issue between a creditor and debtor, it creates a judicial process and a judicial action which the debtor may commence. It's important to note that this bill deals primarily with the relationship between a creditor and a debtor. So if someone who has a debt against them that they believe was done under fraud, duress, or otherwise, that they have the ability to seek recourse vis-a-vis the creditor. There is also a specific mention in the bill about the ability to implead parties who may be necessary to such an action. As Senator Miller alluded to, this bill is vastly improved from the product last year, in that we had extensive feedback, I know, from the judicial branch to make sure that any judicial procedures align with what is currently in statute and what is in the practice book. So urge all my colleagues to support this bill as amended today. Thank you, Mr. Chair.
Senator Kissel?
Thank you very much, Chairman Staffstrom. I'm happy to support the bill to get out of committee today, but I will say I practiced very little family law back when I was in private practice. When I sat for a couple hours in a hallway just down the street at the courthouse, fighting between a photo album and a garden hose. I said, this area of law is not for me. When people are in divorce matters and dissolution of marriage or fighting over their children, it can get real ugly real fast. Unfortunately, while there's probably a lot of salutary uh, points to this proposal, this bill, I also have been made aware by people that practice in this area of law that it could just be another arrow in the quiver of bad actors. In other words, someone may purport to be the victim of a particular set of circumstances, but might be the puppet master engineering all of this just to really hurt the other party in the situation. I was approached by folks from the Connecticut Coalition Against Domestic Violence, a group that I've worked very closely with for well over a decade, probably close to 2 decades now. I'm very honored to work very closely with Senator Flexer and other advocates here in the legislature championing causes to stop domestic violence. And I think in many respects, our state is a real role model for other states, and we're on the cutting edge of good policies. And I think this one has the potential to be that as well. But I will say at this time, I'm concerned with how this plays out in our court system. And I hope that continued work takes place regarding the language such that those people that have far more familiarity with family law matters than I do feel more comfortable that this can't be used as a weapon for nefarious activities between parties that would lead to an unjust conclusion, but would actually be another appropriate methodology to remedy wrongs. So I will be voting yes today, but with a little bit of trepidation, and I definitely hope there's continued conversations between the leadership of the Banks Committee that I have the utmost respect for and folks that have familiarity with family law. Thank you very much, Chairman Stafford.
Representative Fishman.
Thank you, Mr. Chairman. Mr. Chairman, I have an airport in my town. I know. Where's he going now? I chose to get here today. I drove a car. There's a reason why I can't drive an airplane, because I might kill somebody. Somebody else might die. I'm not licensed to drive an airplane. Unfortunately, the proponents behind this bill, it's like me driving an airplane. They don't know anything about the process. No state anywhere in this country has successfully passed this legislation. When I say successfully passed, California has passed, but it just went into place in January, I believe. I spoke to a lawyer in California a few days ago who practices in the family area, and they're very concerned out there. New York has passed a portion of this. I don't think that goes into place until next year. And I think Michigan is the same sort of situation. Last year, we were told that North Carolina had passed it. That was a lie. North Carolina was debating it. It didn't pass. Those looking to travel, to operate airplanes are attempting to use the state of Connecticut as their petri dish. What do we do with this? There are significant problems with this language. You know, to say that the judicial branch signed off on it, the judicial branch was basically told, open up and swallow. It's coming, no matter what. You have to approve something here because it's coming. You know, if those that, there's no portion of this bill that has anything to do with banking. Should have come through this committee in its whole. The banking committee was told that last year, but unfortunately, here we are again. And last year we were told, get it out of committee, we'll fix it. And that was not truthful. The same language that got out of committee, they tried to run. In fact, it ran in the Senate originally. Some of the significant problems with this, when you claim fraud, which is a portion of this, Under our law in Connecticut, the standard is clear and convincing evidence. The standard in this bill is preponderance. So what does that do? It opens up the victim to possible extra litigation at a different standard. That's for this committee to determine. If we're going to bring the standard for fraud across the board down to a lower level, then let's have that decision, that discussion, that public policy shift. It's inappropriate. I think since the very advent of this state, the preponderance, the burden of proof was clear and convincing. There is no statute of limitations in here. So the debt could have been incurred 30 years ago, and one could claim that it was coerced. There's no requirement that the alleged abuser is even alive. So now you're putting, let's say, the credit card company in the position of defending these allegations. You're drawing them into allegations of domestic violence that could have occurred decades ago. There's no other body of law in the state of Connecticut that does that. So let's take a particular scenario. Somebody purchases a car with a credit card, because this language deals with secured debt and unsecured debt. Well, credit card, almost all cases, is not secured debt, right? So they have a American Express black card, let's say. No limit. They go buy a $20,000 car. The credit card company says, pay us. Under this language, they say, no, it was coerced debt. And let's just say that that is successfully litigated. The debtor gets out of having to pay the credit card. Do they have to give back the car? Not under this language. That is not proper. They could have had use of the car or something like that. But if they're claiming that their acquisition of the car was part of domestic violence, the economic abuse, that's recognized. But you can't have your cake and eat it too. You can't make that claim and get out of the debt and yet keep the value of what that debt was for. This language doesn't require that the ill-gotten gains be surrendered. That is a dramatic shift in public policy in this state. We also have the issue of the concurrent jurisdiction, where, let's say, mom has litigated her divorce case. And in the course of that, the court makes a determination that, not necessarily on the fraudulent basis, but in the apportionment of debt, that she's going to be responsible for certain debts and he's going to be responsible for certain debts. And maybe he takes on, let's say, paying for college for the kids because of the imbalance. Because her name is on the credit card, it's easier to deal with. But then 3 years later, she says to the credit card company, I'm not paying this debt. It was the result of this coercion. It's already been litigated through the family court. This language allows reopening the whole thing. We have the concept in this state of res judicata. I doubt that the advocates who have put this thing together have ever heard the term. That means that you've adjudicated your matter in court, and that has some basis to rely upon. This legislation treads on the very foundations of res judicata. When you review the testimony that happened through the banking committee, once again, nobody had the temerity to have a public hearing on this concept in this committee. One of the individuals, and I won't name her, came before the committee and said that this has been a problem for her. And when you look in the judicial website, she's got active cases that are currently being litigated in the court. One of those is a credit card company going after her to collect a credit card. Now, she's already divorced. And, you know, the court has issued their orders. In that particular case, where the credit card company is suing her, she has alleged a special defense. Special defense is permitted by our civil procedure. And it says basically that you may have a claim, but for some reason I should not be held to this claim. And she has specifically said this debt was incurred because it was fraudulently done. And I was coerced into doing it. And the court has recognized this special defense. So it's sort of, you know, without color of basis, that one comes before the committee, the banking committee, and says, I can't get remedy when they're actively litigating this particular claim. It appears successfully in our courts. And of course, the standard there is clear and convincing. Some of the other problems with this is it permits, you know, usually if you're going to disclaim a debt, you're going to say that it was fraudulently obtained. You would think that the notice to the credit card company, let's just say, would have to be in writing. This language permits an oral statement. Well, there's no recording of the oral statement. So the alleged debtor can merely claim that they orally made this statement, and it precludes the credit card company from collecting the debt. Once again, nowhere in any of our statutes do we have such a thing. I could see if it was in writing, that would make sense. You're papering the file. Another problem is that we're giving the power to have this process not to the legislature, but to the courts, actually. Because in various parts of this proposed legislation, we defer to the Connecticut practice book as opposed to statute on whether or not one can do something. It says, for instance, in lines 242 through 244, a debtor may, in accordance with the provisions of the Connecticut practice book, bring an action against a claimant to establish that debt is coerced debt. Well, the term coerced debt doesn't appear anywhere in the practice book. And essentially, I guess, those that draft, approve the practice book, which is not us, it's the judicial branch, could have a practice book section that says we don't recognize coerced debt. I don't think they're going to get to that. But for us to say that someone else, instead of referencing statutes, instead of referencing the procedural statutes that one would follow to file a civil action, which they are out there, we defer to the Connecticut practice book. I did a search last night in Westlaw, and I can't find any other statute in the state of Connecticut that we do that. So all of a sudden, because it's like trying to drive an airplane. The lane here is this committee. very concerned about the concurrent jurisdiction issues, very concerned about the res judicata issues, very concerned about relitigating, which many times re-victimizes individuals over matters that they thought were resolved through our court process. This is not the way to go about this. So I'll reserve my other comments for wherever this bill ends up after this, but Mr. Chairman, this is just not the right thing to do, and there are already procedures in place to deal with this. People do get closure through those processes. This just creates more problems. So thank you, Mr. Chairman.
Representative Osborne.
Thank you, Mr. Chair. And I want to preface my comments with my opinion and my legal belief that this is a really important topic for us to take on as a state. As a strong proponent of coercive controlling relief in family court, I think this is a topic that is ripe for us to undertake. That being said, I am concerned that there are some unintended consequences in the drafting of the bill that remain that don't properly take into account the finality of divorce judgments, and that could improperly or inappropriately curtail the solutions that are available to deal with coerced debt within the context of divorce litigation. So I am looking forward to continuing to work on this bill, because it is a concept and a time and an issue that, you know, the time is ripe for us to address this. So I'm very much looking forward to working on this bill to remove the unintended consequences and ensure the finality of divorce judgments going forward. Thank you, Mr. Chair.
Representative Doucette.
Thank you, Mr. Chair. I do want to respond just briefly to some of the comments of the ranking member and the assertion that a plane is being diverted to his airport, when in fact I think you need to take a step back to look at what we're trying to do here. This bill deals with the relationship between a creditor and a debtor. That is something that is most certainly the cognizance of the Banking Committee, which deals with creditors, debtors, secured and unsecured lending. That's what this bill seeks to address. So to say that the airport is the family court does not completely address what it is that we're talking about here. The ranking member alluded to the testimony of someone who appeared before the Banking Committee who has litigation ongoing and obviously also has an action in family court. However, that litigation that he alluded to is between a creditor and herself as a debtor. It deals with an entirely a distinct issue. The party, the creditor, who is the plaintiff in those actions that were alluded to, is obviously not a party to the family court action. So I think we need to take a step back here and see that there are distinct issues here. It is yes, they're interwoven to a certain degree, but we're talking about distinct issues here. And we would obviously, those of us who are working on this, and I was not involved with the drafting of the Senate amendment, but obviously as the chair of the committee, I've had involvement with this bill over the last 2 years, would invite the good ranking member, would invite those who have experience in the family court to participate and to help us to fix what some of the things that were alluded to. And I won't address all of them. I think some of them may be valid concerns, and others I think can be talked through. But would certainly invite the participation of those who have expertise in that area and are concerned about the intersection of that area and the creditor-debtor relationship that's addressed in this bill to participate and to have those discussions with us. Thus far, those folks have not been willing, it seems, to have those discussions. So again, I would ask the committee to support this today to get it out, and hopefully we can have those discussions moving forward. Thank you, Mr. Chair.
Thank you, Representative. Senator Miller?
Thank you, Mr. Chair. Through you, Mr. Chair, I do align my remarks with my co-chair. Through you, I respect the comments of the ranking chair and his expertise, so much so that I sent him an invitation in October 23 to ask him to please meet with me so that we can discuss the bill that was formerly 1086, because he had some concerns and we wanted to address those concerns. And I thought it was important that we bring this bill forth this year because it is a very important issue and it's an issue that needs to be addressed. So my apologies if my ranking member feels that we brought the same bill forward without considering the comments that were made last year, but we tried to do our due diligence in bringing forth a product that we thought would best address the issue and some of the concerns we had last year. Thank you, Mr. Chair.
Thank you, Senator. Representative Porter?
Thank you, Mr. Chair. I do have some concerns. As a proponent of the coercive control bill we passed a few years ago, I have been in constant contact with many women that are in fact in family court around this coercive debt issue. And I do align my thoughts and comments with Representative Osborne. It causes me great pause, but after listening to this debate, I was going to initially vote no to flag this, but I do know that this is very much needed and this issue needs to be addressed sooner than later. So I've decided that I will vote yes to get this out of committee today, but will reserve the right to vote no on the floor if these issues and concerns are not addressed, because I'm really afraid that as written, it's going to have an impact that's not intended. And I don't want to see that happen to a population of people that are already struggling to get what they need by means of family court. Thank you, Mr. Chair.
Further on the bill, Representative Fishman for second time.
Thank you, Mr. Chairman. I first want to point out that a portion of the airport is in Meriden. So, second of all, I also want to point out that this bill has very long tentacles also. It does not require that the individuals were boyfriend, girlfriend, husband, wife. It could be father, son, mother, daughter, grandparent, grandchild. There is no preclusion. So while those that are pushing for this may feel that there are particular confines to deal with particular areas of relationships, those bars are not there. So, last session when we had this bill, and I believed what the advocate said to me was that it had successfully passed in North Carolina. I had some reliance on that. But then when I looked back and saw that it hadn't, I certainly had pause. As I pointed out before, this concept has not been successfully done anywhere in the country. So maybe the thing to do, and I would totally be in support of, is to have some sort of review as to how those states are dealing with this concept as their brand new legislation, which I think is only 2 states at this point, has rolled out. Because I don't want more problems. Once you open up the door to something like this, it's going to be very hard for this legislature. I mean, people on the outside think, well, just repeal a bill. We all know in this room how difficult it is to go back on things once you've started that. I think the proper course of conduct, is instead of using Connecticut as the petri dish, maybe we look at what California, how the problems that they have to work out through this process. And we don't create more harms for our residents, our taxpayers, our victims of domestic violence. I have a case right now that I've been able to convince the court that the spouse improperly opened up a credit card account. That is a finding of the court. This legislation passes another 2 years from now, or right after that case becomes a final judgment. The individual who has determined to have improperly acted can relitigate the whole issue. That's a problem. It's the problem that California, at least the one practitioner that I talked to, recognizes. And I'd like to see how they deal with it going forward. But for us to jump in with 2 legs and try and operate the airplane, people are going to be impacted. So thank you, Mr. Chairman.
Further on the bill, if not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 123 to JF it to the floor. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer,
Senator Flex votes yes.
Quinn,
Yes.
Kissel, Fishbein, Blumenthal,
Blumenthal votes yes.
Callahan,
Representative Callahan votes no.
Conley, Curry, Delaney,
Representative Delaney votes yes.
Dillon, Doucette,
Doucette, yes.
Kibitsky,
No.
Elliott, Gaston, Gilchrist, Godfrey,
Godfrey votes yes.
Hall,
Hall votes no.
Harding, Hayes,
Hayes votes no.
Howard,
No.
Johnson,
Johnson votes yes.
Khan, Labriola, Lesser, Marr,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes no.
Osborne,
Osborne votes yes out of committee.
Havelock D'Amato, Porter, Sampson, Sims,
Sims votes in the affirmative.
Beach. Beach is a no. Walker, Wilson,
Madam Administrator, please call the consent calendar.
roll call vote on the consent calendar consisting of House Bill of 5168 and 5288. Winfield,
Winfield, in the affirmative.
Staffstrom, Flexer,
Senator Flexer votes yes.
Go back and
Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal,
Blumenthal votes yes.
Callahan,
Callahan votes yes.
Conley, Curry, Delaney,
Delaney votes yes.
Dillon, Doucette,
Doucette, yes.
Kibitsky,
Yes.
Elliott, Gaston, Gilchrist, Godfrey,
Godfrey votes yes.
Hall,
Hall votes yes.
Harding, Hayes,
Hayes votes yes.
Howard,
Howard, yes.
Johnson,
Johnson votes yes.
Khan, Labriola, Lesser, Marr,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes yes.
Osborne, Havelock D'Amato, Porter, Sampson, Sims, Beach. Beach is a yes. Walker,
Sims in the affirmative.
thank you. Wilson,
All right, That'll conclude our business for today. We will stand in recess until 2 o'clock. Have a good weekend, everybody.
Madam Administrator.
Representative, how are you?
Fine, thanks. I just wanted to verify whether I missed any votes.
All right, I'm gonna double check. No, I did, I missed you. You only missed 522. Yeah, so for 5226. Representative Blumenthal? For 5226?
Blumenthal votes yes.
Awesome, and you're all set. Thank you so much.
Thank you very much, Madam Administrator.
So, can you just Representative Conley, how are you?
Good, how are you?
Good, good. So for Senate Bill 123, how would you like to vote?
Conley, yes.
For that's for 5226
Conley, yes.
and 5331.
Conley, yes.
And then we did a consent calendar of 5168 and 5288. How would you like to vote?
Conley, yes.
Okay, we're all set. Thank you so much.
Thank you. Have a good weekend.
You too. Senator Sampson?
Hi there.
Can you hear me okay? Senator Sampson, you there? I can't hear you.
Can you not hear me?
There you go. That's perfect. Yep, gotcha now.
Oh, that's weird.
All right, so we put items.
Started working.
Yeah, right. Items 2 and 4 we put on consent for item number 1, Senate Bill 123. How would you like to vote? Yes.
I am a no. Sampson, no.
Simpson's a no. For 5226,
Sampson, no.
5331,
Sampson is no.
and then consent calendar.
Yes.
All right, you're all set. Thank you so much.
Thanks, Kristen. Appreciate it.
Hi, Representative Osborne. How?
Hello, I think I missed my vote on the consent calendar. Oops, I can't hear you for some reason. Oh, can you hear me? I can't hear you, but I vote yes on the consent calendar.
How about now? I'll mark you down as a yes.
That works.
Yeah?
That works.
That was weird. Okay, so I have you yes for the consent. I have this.
Think
and
I
I
have
missed you for 5331.
Oh, I missed that?
Yep, I didn't get you for that one.
I vote yes on that.
Okay, you're all set.
Thanks so much.
Thank you. Have a good weekend.
Bye.
Senator Lesser,
Hello.
how are you?
Good. How are you?
Good, good. So we have items 2 and 4 were on consent. The rest we did roll. So for item number 1, Senate Bill 123, how would you like to vote?
I'm sorry. Item number. Let me just pull it up.
No worries. First one's from Banks and that concerning coerced debt.
Oh, yes. I'll vote in support.
Yes?
Yes.
Okay. So in that one, I've brought you for 5226. So 5331, which is item number 5 on the agenda.
I will vote in support.
Okay. And then for the consent calendar.
I'm in support.
Okay, you're all set. Thank you so much.
Thanks.
Have a good weekend.
You too.
Representative Delaney, hi Senator.
Hello, how are you?
Good and yourself?
Good, good. Sorry to have you waiting around like this.
No, you're actually very prompt. Votes are open till 2, so if it was 1:55, that would be different.
I know. So,
Right. So we had 2 items for consent, items 2 and 4. The rest were roll call.
okay, yes,
So for the first one, Senate Bill number 123.
yes,
All right. For 5226,
yes,
for 5331,
yes,
and then for the consent calendar.
yes.
You're all set. Have a great weekend.
Thank you. You too. Take care now.
You too.
Hey, Kirsten.
How are you?
Doing great. How are you doing?
It's peachy today. All right, so we did
Right.
the two bills on consent. We had items 2 and 4. Can you hear me okay still?
I can hear you just fine.
Okay, perfect, because it went out in the hearing room. Okay, so 2 and 4 were on consent. So for item number 1, SB 143, how would you like to vote?
Yes.
For 5226, how would you like to vote?
Yes.
For 5331,
Yes.
and then for the consent calendar.
Yes.
And you're all set. That's it.
Thank you.
Have a good weekend.
Have a good one. You too.
Hi, Kirsten.
Hi, Senator, how are you?
Good, how are you?
Good, good. All right, so we put two items on consent, items number 2 and number 4. So for the first item, Senate Bill 123, how would you like to vote?
I will vote no.
Okay. For item number 3, which is 5226, how would you like to vote?
Yes.
And for item number 5, 5331, how would you like to vote?
No.
And then on the consent calendar.
Yes.
Okay, you're all set. Have a great weekend.
Thank you, Kirsten. Have a good weekend.
Take care. Hi, Representative, how are you?
Good, how are you?
Good. All right, so we put two items on consent, items 2 and 4. One was from P and D and one was from Vets. So item number 1, Senate Bill 123 from Banks. How would you like to vote?
Yes.
Item number 3, which is 5226 from Environment.
Yes.
Item number 5, 5331 from Transportation.
Yes.
And then on the consent calendar.
Yes.
All right, you're all set. Have a great weekend.
Thanks, you too. Bye.
Representative, can you hear me okay?
How you doing?
There you go. Good and yourself.
Good, good.
So we had two items that were placed on consent today, items 2 and 4. So number 1, Senate Bill 123, how would you like to vote? That one came from Banks.
No.
Okay. Item number, hang on a second. Item number 3, 5226,
Yes.
53. Hang on a second. 5331,
No.
and then the consent calendar.
Yes.
All right. You're all set. Have a good weekend.
You too. Thanks a lot.
Hi, Representative, can you hear me okay?
Good afternoon.
How are you?
Fine, thank you. We're still in the probe, so I thought I should stop by before they conclude the hearing.
Absolutely. So
I believe I missed a couple.
Yep, so we had two on consent for the first item, was Senate Bill 123. That one came from Banks.
Yes. Right. The course.
That's right,
yes.
course that is number one. Yep, so you're a yes on that?
Yes.
Okay. Item number 35226 came from Environment. It was the Responsibility Program for Consumer Batteries.
Yes.
Okay, and then 5331, that one came from Transportation.
Which one is that?
You voted yes. You voted yes on that already. And then the consent calendar.
Okay.
How would you like to vote on consent?
Yes.
All right, you're all set. That's everything.
Thank you very much.
Thank you. Have a good weekend.
You too.
Madam Administrator,
Hi, Senator Malia.
hi. I
So
think I
I-
missed one bill.
You did for 5331.
Yes,
Okay, you're all set. Thank you so
thank
much. Have a good
you.
weekend.